All right. Well, let's go ahead and get started. Thanks again for being part of the Tuesday's contract class. So the last inspection, final investigation of condition. Again, all of the training platforms are right from the purchase agreement, disclosures through zip forms, or the California Association of Realtors as well. So let's dive deep. All right, so in the beginning of paragraph 3L, subsection 3 and 8C and 12 of the RPA purchase agreement defines a buyer's contractual right to investigate the property and matters affecting it. By default, within the first 17 days after acceptance, a buyer has the contractual right to conduct what is known as an inspections, investigations, tests, surveys, and other studies of any concerns regarding the property. A buyer, through other or their own, may have what's called a general home inspection, investigations of and availability and cost of floor insurance or fire insurance, or conduct any investigations only limit by the buyer's curiosity and money. So basically, if we were to dive deep into the zip forms, okay, and this is an illustration of the purchase agreement, but I'm gonna go back to the RPA as an example. And the RPA gives us, and why is this not coming up? It's not coming up. Okay. It provides us with a segue of what the RPA illustrates. So under the exercise of the purchase agreement, it gives us a perspective that subsection 3L talks about the investigations. And I know I had a conversation about 2-3 weeks ago on this that talks about the investigation of property, which is already defaulted to 17 days after acceptance, right? Then it also goes into section 8C and 812, and I'm going to dive into that as well as part of the purchase agreement. And it talks for informational access to the property, that the buyer has the right to access the property for informational purposes. It's not necessarily a contingency, but it does create an avenue that the buyer cannot unilaterally cancel after releasing that as a contingency, right? And applies as part of it once the buyer releases investigation of property, meaning doing the buyer's due diligence. Then obviously with that, it also would populate the removal or the waiver of the contingency, right? And there's a set of different types of conditions that need to be met, and either is the buyer moving forward or is not moving forward, they're planning to cancel. Okay, so this is where it talks about the default within the 17 days to perform, and then ultimately under section 8C, it goes into the language that says about the investigation of property. And it says on the RPA the following: this agreement is specified in, which is the grid of paragraph 3L3, contingent upon the buyer acceptance of the condition of and any other matter affecting the property. Then we go to subsection 12, and 12 illustrates the position that talks about what are the due diligence that a buyer needs to do to satisfy themselves to the overall condition of the property. And it says, and it defines on the RPA, it says that buyer's investigation of property and matters affecting the property. Buyer shall, within the time specified in paragraph 3L3, have the right at buyer's expense, unless otherwise agreed to. Again, everything is all agreed to. That's why we created these purchase agreements, to define who is responsible for what, right? If the buyer's going to be paying it, if the seller is going to be paying, whatever that looks like, right? But it defines that an investigation, tests, surveys, or any type of studies can be done as part of the buyer's investigation. It also states the fact that inspection is regarding any physical attributes of the property or items connecting to the property, such as what we call a general home inspection, an inspection for lead base, an inspection for termite, an inspection for plumbing, covers detached structures such as a detached garage, maybe it's an ADU, or maybe it's a duplex. That is all encumbrances regarding the parcel and what the buyer's responsibility to do a thorough inspection of the property. Any inspection specified in either the termites, such as subsection section 1 and section 2. It also goes into, any insurance, fire insurance. It talks about all of the severity of the property: roof, plumbing, electrical, floors, foundation, structural, landscaping, anything and everything. The buyer has the right to do some type of inspections. Now, they can also waive those inspections as well as part of the condition, and that will enhance the position that the buyer is, one, very serious, but two, it also illustrates their motivation too. But I caution you and your clients, if you're going to go into that perspective, right, where you're going to reduce the condition from the default of 17 days down to maybe 10 days or 5 days, or if the buyer is going to waive that as part of their negotiations. Remember, once a condition is removed or lifted, there's no going back. You either decide to move forward, or there's going to be consequences when it comes to that. Okay. Yeah. All right. Well, let's go ahead and continue here.
It did it fucking together.
Please make sure to mute yourself if you haven't already. All right. I think I got everyone on here. So again, thank you. All right, so the next, although the seller is contractually obligated to make the property available to the buyer, and the seller is not obligated to move any existing personal items. So here's the do's and don'ts, right? Buyer gets an offer accepted. The buyer now goes into the motions of doing their due diligence inspections, right? And there's inspections in the beginning. There may be inspections closer as we get closer to closing, and then what we call the final inspection, which is the verification of the final walkthrough before we close. And I'll explain in how all that works as well, because you need to understand the elements of what your position is if it comes to that end, because you can also waive the final verification. And it's funny because on today's team meeting out at the Long Beach office, I was talking a little bit about the importance of doing your due diligence, right, and making sure that you are having those conversations with the consumer, the buyer, and that it's always a risk when they're reducing their contingency period or waiving their contingency period. So you want to be able to know how to navigate, but more so, let's say that as we get closer to closing, everything is solid, the buyer is approved, the conditions have been met, and the lender is ready to get through the motions of funding the loan, and then obviously the steps of closing the deal and recording, right? But what if you see a dilemma that looks similar to the slide, right, but there's still a lot of personal items? Now, my biggest way is communications, right? Communications, and that's the avenue that you're going to be able to navigate this in a win-win, right? Because if you see a lot of personal items and you're going to be closing in less than 5 days, it's obviously a concern. Now, obviously, the conversation will be mutual between both agents, because sometimes at the end they're moving out of state, this is why. But if you don't see boxes, or at least a little bit where it looks like they're moving, then you need to start having conversations. Hey, you know what? After doing our final walkthrough of the property, it looks like the seller doesn't look like they're packing or doing anything to make themselves look like they're ready to move out. You definitely have some options here, right? Extension of time, get the brokers involved, and have those conversations with your clients, right? As a consequence, the buyer may not be able to learn everything about the property, right? So what if you're in a situation, the seller is not obligated to move, furniture on behalf of the buyer, right? Because the buyer wants to do their inspections, right? It's limited, but it's also your engagement and your opportunity to say, hey, that china that is in the dining room area, it just seems like there may be some concerns behind that. Obviously do your observations, and this is why it's vital and important to do an avid, right, a visual inspection of the property. Now, as I stated earlier, you're not going to be moving things, right? You're not going to wear a hard hat, jump on the roof. You're not going to be moving furniture, right? But if something does arise after doing your final walkthrough, then that's when you need to proactively be engaged in a conversation and obviously put something in writing, right? Because when you put it in writing, now it's set in tone that what are we going to do to resolve this? What are we going to do to make sure that we're going in the right direction, right? Even if there is no investigation or contingency, or it is removed early, the buyer has the contractual right for a limited period of time after acceptance to access the property, maybe to measure rooms, or have a contractor give an estimate for work to be performed later, which is part of the RPA 3L3. Buyer is in most cases should give up the investigation rights early. So again, even if the buyer releases physical inspections, folks, okay, they release it from the very beginning, the buyer still has 17 days to do their visual inspections of the property. You cannot deny, the seller cannot deny the buyer to do measurements of the property. Maybe they want to knock down a wall. Maybe they want to extend the property and add square footage. Maybe it's a 2-1 and they want to add a second bathroom or an additional bedroom, right? The buyer has the right to have access to the property. Now, that's also part of a counter offer in the negotiations. If you do not counter that, then even though the buyer has released physical inspections, the buyer still has access to the property to do their due diligence. Okay, so I want to be very clear that we, as an agency, as a brokerage, and as a listing agent, we cannot deny that request if the buyer chooses to go in the property for access purposes. Okay, so in the middle, if the buyer and the seller negotiate repairs, the repair shall be performed in good, skillful manner, and the work completed at least 5 days prior to close of escrow. So here it is, folks. This is why real estate is so dynamic and it's so awesome, because it allows the buyer to do negotiations in the beginning, right? Getting your offer accepted, working on price, terms, and conditions. Once your offer gets accepted, now you go through the motions of the due diligence period, right? To make sure that the buyer is completely satisfied with the overall condition, right? And that's the most vital time in the transaction is, what is it that we're going to find? What things are going to come up, right? Plumbing, electrical, floors, whatever that case may be. That's the middle process, right? This is a part of the negotiations. Buyer may ask for a request of repairs. Buyer may ask in lieu of a repairs to do credit. Buyer may say, instead of lieu of credit, in lieu of repairs, I want you to request a price reduction, right? Or guess what? The buyer can also ask for all three: price reduction, credit, and do some of the repairs. And that's all part of the negotiations. What the contract also stipulates and says under RPA, it talks about that once you come to an agreement, if any repairs are going to be done with the property, that within 5 days of closing this, that those repairs have been taken care of. And this is why the buyer has their final walkthrough on the property to make sure that what was requested and agreed upon, that the seller has performed, that the seller has done the necessary repairs to the property. The seller also has the obligation to deliver the property in the same condition as it was in the deed of acceptance, plus agreed repairs, and to remove debris and personal property not included in the sale. So here it is. You're the listing agent, right? You list the property, you have these beautiful photos, you stage it, you make it look very pretty, right? Landscaping is another vital position as well, right? Just because you got an offer accepted doesn't necessarily mean that you stop everything, right? You stop watering the grass. You let the house go to shambles, right? No, the seller is still responsible to maintain and keep up the property till it officially closes. So what the RPA states is that it is still the seller's responsibility to make sure in the obligation that the property is in the same condition as when originally submitted an offer. Meaning when I or my client submit an offer, because we saw it, we submitted an offer, that the condition of the property, if a window is cracked or broken with an escrow, well, that falls on the seller. They're still responsible for the property. They're not going to be able to say, well, you know what, I'm in escrow, the buyer's eventually going to buy this property. Oh, well, the buyer's responsible for fixing those repairs. It doesn't work that way. The seller is still obligated and owner of the property. They have to take ownership for that as well. If the buyer must wait until close of escrow to confirm these seller obligations have been met, the buyer loses all leverage to receive a property as promised. The buyer protection is the right to conduct what's called a pre-closing inspection, better known as the final verification of walkthrough, right? This is why it allows you 5 days prior, right? Does that mean you got to wait till the last day before it closes? No, because then you're not going to have enough leverage and enough pull where that's going to not help you get a problem solved. Because by that time, if it records, the issue that you have here is that you're not going to be able to extend the time period. Okay. And when you have that extension, you at least have that momentum not to close, because remember, you're also holding the seller hostage from them, performing, because they're anticipating the net proceeds of the sale of the home. They're not going to be able to do so because we put an extension of time. I hope that kind of makes sense. So the obligation and obviously the position that you want to be is you want to be on the forefront and doing what you need to do to make sure that we're all on the same page and in alignment, that both the buyer and the seller are, in communications through the agents, right? So this is why the final verification is vital. It's something that you do not want to waive. You want to go there and make sure that the property is still in the same condition as was originally offer was submitted, and make sure that any repairs that were done to the property, that they were done. And if they're not done, that gives you an opportunity on the final verification to put this into the final walkthrough. Okay. So here's a sample of the verification of property condition by our final inspection. Okay. So it's pretty self-explanatory. There's really not much. It's a 1-page form that goes into, talking about what we just said. RPA paragraph 16 gives the buyer the right for a pre-closing to verify the condition of the property. While not a contingency, it is its own right. Paragraph 16 could trigger a buyer right to delay or prevent the closing from material breach, or negotiating for an otherwise acceptable solution if the seller contract obligates have not been fulfilled. So again, it's a protection. All right. It gives you the momentum to say, hey, Mr. and Mrs. Seller, we have an issue here. Obviously, our concern is X, Y, and Z. These things have not been performed. Otherwise, we're not going to close. We're going to put a request to escrow to delay the closing. Okay, so it gives that momentum that also the buyer has a little bit of leverage that will give that upper advantage to delay the process. But also it gives the buyer the opportunity to let the seller know that they have breached the contract as well. And that's defined in the purchase agreement that says that, if the seller does not leave the property as originally saw, then the seller is in breach of the contract, and therefore there might be damages that may incur, right? And that can also delay the process from closing the deal. The form VP verification of property condition can be used to document the results of the final inspection. Okay, so let me see if this, no, it's not going to come up on my end, so I'm not even going to bother. So here's a sample of what the verification. So what it says is you're going to put the property address. 1 and 2 and 3 is 1, A, and B. The purpose of this inspection is to satisfy the buyers regarding the condition of the property. B says, unless otherwise agreed, buyer and seller understand and agree that a final inspection is not a contingent of this agreement. The verification of property or its waiver is not intended in any way to alter the contract obligation of the seller regarding the condition of the property to be delivered to the buyer at possession. Date is not the base upon any statement or representation by the broker, associate, license, or brokerage and employees. Section C says that the parties agree to hold the broker, associate, license, and the brokerage employees harmless from any liability claims. Okay. And then the buyer's acknowledgement, right? Property is sequentially the same condition as the date of acceptance of the offer to purchase and sell, and seller has completed any repairs, alterations, replacements, or modifications as agreed to by the buyer and the seller within the following exceptions. So if there is some concerns or some issues regarding the final walkthrough, this is your time and illustration to put it in writing. Okay, this gives you some paper trail, but it also documents a series of concerns if the seller did indeed breach the contract. So again, this is one of the last forms that you'll be involved in through the escrow period and process. The buyer does not need to be present, but can choose to have a professional inspector conduct the verification. Discovery of any new problems will not trigger the rights of the buyer to be compensated if a problem exists at time of acceptance and was overlooked during the initial investigation. Even if personal property is placed, preventing the discovery initial, the final verification should be exercised as a routine matter and only waived in unusual situations. So I want to make sure that I'm very clear in my approach, right? That ultimately the final verification doesn't necessarily mean, and I would encourage you, but it doesn't necessarily mean that the buyer has to be physically present to do the final walkthrough. If the buyer chooses to get a professional inspector, maybe they needed to get the AC or the water heater or the sink or whatever that looked like, right, as part of the negotiations, that was taken care of, then it's perfectly fine to get the true professionals to evaluate. And there's been a lot of agents that do so, will have their pool inspection done, right? And then they put that request and they say, well, it's going to be about $3,000 of repair to fix the filter or the motor of the pump that circulates the water and ultimately filters out, right? Then the seller agrees to the terms and says, look, in lieu of any credit, we're going to go ahead and take care of that. And now you got a bill of sale that says that it was taken care of. Now on your final verification or walkthrough, the buyer or the buyer's pool inspector can go out there, evaluate and make sure that it was done in a professional manner, right? And this is, again, because we're not experts in pools, we're not experts in HVACs, we're not experts in electrical, we're not experts in roof. you want to hire the right people to make sure that, yes, you know what, thumbs up or thumbs down, something was done incorrectly, we need to evaluate, so that gives you an avenue to have that documented and ultimately sent out to the listing agent, where the listing agent now will turn around and send it over to the seller, right? And then it's all part of the negotiation. If that means that it's not going to be taken care of and you know that it's going to close in 3 days, then immediately we need to proactively be in communications with the agent and see what we need to do. Does that mean we're going to have to extend another 2 days to make sure that this is taken care of? Whatever you take, because once the deal closes, right, then it's hard to navigate that situation where now it's going to be even harder for you to, get involved in a claim and all that. So instead, be engaged, communications, make sure you're in dialogue with the agent, and ultimately try not to close escrow until you come to some type of agreement, right? We're not going to close escrow. We're going to extend it another 2 or 3 days to make sure that these items are taken care of. So that way the buyer's happy. Okay. The seller doesn't just close the deal and then move and we never hear from the seller, right? And those are far and few, but I'm just illustrating that something can happen as well, right? So now we go into material versus immaterial breach, right? So if, for example, the buyer discovers a tree limb damaged the roof, or the seller failed to properly correct a foundation problem, the buyer would likely have a legal excuse not to close escrow, right? Well, if you look at this illustration, right, you didn't see this tree originally damage the roof, right? But during your due diligence or even your final walkthrough, you realize, holy cow, we have a tree now on the top of the roof. That is definitely a concern. That is definitely something that, it's gonna put a red flag. And I would not close on something like this, because now we have to get the seller involved and maybe insurance claim to make sure that this is taken care of. Now, this is a drastic, right, circumstances. Typically, you don't see something like this at the very end, but things happen, right? I've been in scenarios where we're about to close, and a significant partner or other passes away, and now that changes the trajectory from closing, right? We had another scenario with one of our agents represented the tenant lived in the place. The seller wanted to sell the property, was going to sell the property to the tenant, and as they were going through the motions, they had open escrow, the seller passed away, and now you're in limbo, and now you're kind of like just waiting for what the next step is. And unfortunately, that particular scenario did happen. The owner did not have a trust, so they had to go through the motions of probate. So it extended, and ultimately the buyer had to cancel escrow. They're still in the property, and eventually one of the family members got involved, got the probate started, had the probate approved, and then ultimately went back into the motions of putting the property back in escrow, and successfully they closed. But it took almost a year and a half after for this to happen. So again, just a segue of things that can happen. It doesn't happen that often, but if it does happen, you got to be in the forefront of those conversations, right? So and let's see, if for an example, the buyer discovers a tree limb, okay, if however the seller fails as agreed to fix a loose handle on a toilet, the seller would still be in breach. Again, common sense, right? This is why at the end of closing the deal, the final verification is vital, because that gives the buyer the opportunity to go evaluate the property and determine, okay, is everything working? Yeah, everything is solid. If something falls apart, then obviously it's something that you can document and put it into the final verification. The buyer could sue for the cost of repairs at the close of escrow, or try to negotiate a credit at close of escrow. So there's a lot of avenues that can happen. This is why I encourage all of you, if you are in a transaction that that you do a final verification. All right, don't waive it. Get that final verification squared away, because that'll save you the heartache and issues down the line. Seller in possession after close of escrow. The buyer should conduct the final verification before close of escrow, even if the seller will remain either pursuant to a lease after sale or a short-term license. So regardless, and I get this quite often, folks, is should I still conduct a final verification or walkthrough if the seller is still going to stay in possession after close of escrow, or if a tenant is going to still be occupying the property or the premise? The answer is yes. Yes. You still want to do the final verification to make sure that you're protecting yourself and that you are following the process. Then the answer is yes, you want to do a final walkthrough on the property. By doing so, seller breach can be negotiated prior to close, and any problems that are discovered after the seller is up possession can be more easily attainable to a pre-closing or post-closing breach, and would potentially be covered by the buyer's insurance. So again, I hear from all different agents, well, the buyer doesn't need to do a final walkthrough because the seller is going to stay in possession. We'll do the final walkthrough after we know that the seller, within 3 to 5 days, they vacate the property. We'll do the final walkthrough. No, that's not the way it works. The contract is very clear and concise. You need to do the final verification, a walkthrough prior to close of escrow, not when the seller leaves the premises. If it's 30 days or 60 days, whatever that is, it's close of escrow. The buyer still has the right prior to the seller staying in possession, that the seller has, the buyer has the right to do their other inspections and making sure that any additional damage that was done, right? The final walkthrough, they saw that everything was done, was okay. And now they go 30 days later and realize that one of the windows is cracked. That gives you an opportunity to address it before the seller or the owner leaves the premises, right? So you get to do, final inspections on the property before close of escrow, and then once the seller, after possession, decides 30 days to leave the premises, the buyer still has their right to do their due diligence and inspections. Okay, and therefore that also protects the buyer, because the buyer can claim, well, that was not in existence prior to close of escrow, which I was not the owner, but now that I'm the owner of the property, you have property insurance. Now it's a give and take, right? You can hold the seller responsible, which in most cases that's the case, or you can also file a claim that says, prior I did not have the insurance, but now that I am legally the owner of the property, I do have insurance to cover me these times. But it's also the owner's responsibility that, if the seller is in possession, it's a temporary license to stay 30 days or less, or 29 days or less, right? Anything more than 30 days, then you would have to do more of a lease agreement type of a position that would honor and protect your clients from any insurance claim as well. So you want to make sure, is it a tenant or is it a temporary tenant? So those are the distinguishes. This is why they're created into two forms, one for less than 29 days in possession and one that is 29 days or more. The buyer does not have the right to inspect the property during the seller's continuing occupancy, except in cases of emergency or to make agreed upon repairs. Okay, so what it stipulates is that, the buyer does have the right to do it. No difference than a tenant landlord position, right? You're the owner. If it's something that is say a toilet or gas leak or electrical, then those are urgency things that, yes, you do have the right to go in there and do the due diligence and making sure that the property is taken care of. Because you don't want to have a problem with the property, and therefore when the owner of the property takes possession of it, now you have all these problems. It's really the seller's responsibility as the tenant. And it's also the buyer's responsibility, who is now the landlord, to make sure that they're in agreement to. But as it says, is that the buyer does not have the right to inspect the property during the seller's continuing, but after they vacate. So if we know it's 29 days, on that day, this is what we call in the move in and move out period for the owner to have access to the property. There's additional resources that you also can jump into with a quick guide. The last inspection, which is part of it, you can get it right through the California Association of Realtors. There's also the quick guide on negotiating after inspections, real estate license duty of an inspection, and Q&A use of the request of repairs, and the response of the buyer's request of repairs. And then we have the Q&A for real estate license duty of inspections. And then the Q&A for the termite wood destroying pest, inspection reports, and repairs. Okay, so with that, is there any questions regarding today's topic? It's pretty self-explanatory. Again, just to kind of recap, our position is that once you're involved in a transaction, the importance of doing your due diligence on the final verification of walkthrough, that the buyer is performing and that the seller is performing. This is why the buyer has the ability to do a final inspection to make sure that the property is in the same condition as it was originally saw and accepted, and more so if the buyer had put any type of request, that also has been taken care of. Okay. And if you have any additional questions, feel free to reach out to me, send me an email. I'll be more than happy to address any questions regarding today's topic, or any RPA, or any of the disclosures and forms that are provided by the California Association of Realtors. With that being said, if there's no additional questions, I appreciate you all, and we'll see you on the next contract class. Thank you.
Simon.
Thank you. Thank you, Simon.
Thank you. Thank you. Thank you.